Good morning, everybody. I apologize for our delay this morning. Welcome to the District of Columbia Court of Appeals. I understand we have some students from Dunbar High School here today, so welcome to you. We have three cases on this morning's regular calendar. The first one is numbers 24 CV 439, 444, and 480. It's 2135 Northeast LLC versus DLY George's Warehouse LLC, et cetera. Whenever you're ready, counsel.
Thank you. May it please the court. Good morning. My name is Philip Mussolino. I'm counsel for 2135 Northeast LLC, the owner of the property at 2135. Mr. Metz is a counsel for EKHO Stage and EKHO Events. We've elected to divide our time evenly, 7.5 minutes.
Okay.
And we'll reach hoping to reserve 2.5 minutes each for our rebuttal.
2.5 minutes each, you said?
Pardon me? Yes.
Each?
Yes,
Okay.
Your Honor.
We'll do our best.
So if I could begin, Your Honor, from 2135's point of view, we're going to address three issues. We'll address them briefly. I think they were addressed comprehensively in everyone's brief. The first is whether or not procedurally the declaratory judgment action was premature. That is to say that there was not sufficient ripeness or concreteness to the claim. And it's our position, I think the authorities are substantial on it. And Appellee agreed at page 46 of their opening brief that immediacy, concreteness, and reality are essential elements to a declaratory judgment action to avoid having courts wade into the advisory opinion world. In this particular case, when the Judge Rigsby, I'll refer to as the motions judge, when the motions judge ruled on the motions for summary judgment, he ruled on both the declaratory judgment count and on the count for permanent injunction. He granted the request for relief in the declaratory judgment account without addressing the immediacy issue. He denied the summary judgment motion with respect to the request for permanent injunction, finding explicitly that there wasn't sufficient immediacy or concreteness to warrant an award of permanent injunction as a matter of law.
Well, I guess your argument is that there's a conflict there, but did you were you the trial? Were you the person in trial?
No, Your Honor. By the time the case went to trial on the permanent injunction count, we had entered into an agreement with DLY, the appellant. They dismissed us from the permanent injunction count.
Okay, so I
all agreed by virtue of the stipulation, which is in the appendix, that we wouldn't use the results of the permanent injunction hearing against each other for a variety of purposes, including issue preclusion, fact preclusion, and the like. So we were out of the case.
Okay, but I guess the question is, was this problem pointed out to Judge Rigsby? You know, did he have any basis to rule on the argument you're making now?
Well, we argued in our opposition to the motion for summary judgment that there was a need for immediacy in with respect to declaratory judgment. The defendant has argued that the cases we cited were administrative cases, but that's not what the declaratory judgments are limited to under the Federal Declaratory Judgment Act, which is incorporated by our Rule 57 in Superior Court. The declaratory judgment acts are always civil actions.
Can we just put some meat on the bones? Because,
Sure.
you know, the complaint is this, you know, you have a tenant there who is parking their trucks for periods longer than necessary to actively load and unload the truck. That's immediate enough. They're saying it's going on right now. They're saying it happens habitually. Here are a few instances of when it's happened. Tell them to stop. What is lacking there in the immediacy calculus? They're saying it's already happening.
Well, of course, you have the judge who's already determined that there isn't sufficient immediacy in order to award.
Well, there's a second, then there's Judge Williams ruling that that those violations are not in fact occurring, but that's that's the fight here. Like, why? So why aren't we talking about whether or not that was a good ruling?
Two issues. First, Your Honor, with respect to the parking issue versus the temporary loading and unloading issue. That is not an issue that affects us in the first place. By that, I mean the building owner. We have already given up our interest in the property for purposes of possession and use. We have 3 years left to go on that lease and another, I presume it's in the record, 5 years to go on an option. So with respect to DLY as the owner, we are out of the picture, and that's the reason that we were dismissed out of the suit for permanent injunction in the first place. And I would point out that back in the first time we were up here on the preliminary injunction request, when we were seeking a preliminary injunction, one of the arguments that the motions judge relied on was that we were the owner, not the tenant, and we really didn't have an immediate impact or involvement in our request for a preliminary injunction. So first, with respect to a declaratory judgment action against 2135, as opposed to people who were actually in the dispute, we weren't parking, we weren't unloading, we weren't loading, we weren't doing anything. And had no intention of doing anything, and made clear on the record.
Yeah, I appreciate that. Maybe this should be put to your co-counsel, to the tenants council. But I guess my question is, when we're talking about whether or not the declaratory judgment was premature or unripe, I mean, you're definitely right if there's no violation at all. Well, as the later trial judge found, well, then there can't be a declaratory relief because there's been no violation for which declaratory relief should be granted. That's just a weird, I mean, I feel like we can just stop there though. And the conversation should now move to whether or not there's been a violation, which I guess comes up in Appellee's appeal more directly than yours. And maybe, you know, I suppose I'll save my questions for co-counsel.
Although I would add a gloss with respect to what Judge Williams did, as I understand, and this is not for me, better lawyers more familiar are going to present this, but as I understand EKHO Stage's position, what the brief suggests they were trying to get to, and what DLY's brief suggests we are trying to get to through our interpretation of the easement as being for unimpeded access, is the right to park for hours and hours and hours, even though you're not in the loading and unloading process. And as I understand it we have no interest in that. We're not parking, loading, or unloading. As I understand it from EKHO Stage, they are not asserting and never asserted that they had the right to get into the weeds of it all, park their giant trucks, unload these $20,000 worth of equipment and sit there till this hours-long show was over. As I understand it, the testimony, no, I'm the wrong person.
Sure.
Testimony was truck pulls up, they unload all this fabulous sound and cryo, whatever the smoke and all the other equipment is, drive their trucks away and come back to pick it up. And the loading and unloading apparently is an enormously complicated process. So even there, I don't understand that there's a concrete dispute, except that DLY wants some kind of ruling that they can't park, and EKHO Stage is saying for purposes of what we do, we don't want to leave our trucks there while the show is on. To sort of get into the weeds of the facts, as I understand them, maybe incorrectly. But in any event, as to us, not involved, and as to parking, if you look at the way the case played out, Judge, pretty clearly Judge Williams' decision was that that the conduct that was concerning DLY wasn't taking place.
I mean,
He says not only wasn't there
I don't know how clear her ruling is on that. The problem with her ruling is she goes through these, you know, the truck is parked there for 5 hours. Are they actively loading and unloading in that time? This is in one of the instances, it was about 5 hours. There are several instances that they're highlighting. And the answer to that question is nowhere to be found in Judge Williams' ruling. She seems to say, well, that's encompassed within the allowance for parking for purposes of loading and unloading. But I don't know what she means. I don't know if she means, and you can sit there and wait as long as you want to reload the truck, or if she means these are such complicated unloading and loading procedures that I think it was continuously happening. If you think that's clear from her findings somewhere, I'd love to see where, because like that's exactly the kind of finding I would want. And I've read her ruling several times, and I don't see where she's being clear at all about what's going on during these lulls where the trucks are parked there. And that's kind of finding I think we need.
So,
I mean, that was an invitation. If you
I
have the finding that you say loading was happening throughout these long lulls, where would you point me to?
So I respectfully request the right to punt. Your Honor.
That's fair, that's fair.
But I understand, and I would try to address it, but Mr. Metz is far more capable of addressing.
Okay.
What I understand is Judge Williams ruled not only wasn't there an irreparable injury, there was no injury at all, but that the details of it, Your Honor, I'm happy to defer to Mr. Metz if the court will.
Can you
permit.
say what specific remedy you are asking us for?
So what we've asked for, Your Honor, is a reversal of the declaratory judgment. To the extent that it is inconsistent with my client's right to unfettered access. And so counsel suggests that the judge came very close to giving us that. Although if you look at the judge's omnibus order,
I mean, you're talking about the part where Judge Rigsby says there's no restriction on DLY's use, right? Is it, and it,
on 2135's right for, yes, Your Honor, you are
and
correct.
so isn't it, I mean, that could be, I understand why you would be worried about that, but you use the term to the extent that it's kind of unclear what it really means in context, especially given that DLY, I think, wouldn't even disagree. They know there are restrictions on their use. Everyone, you know, that's what the easement is.
Right, I agree with that, except that the judge's order and defendant correctly points out that the judge said there is no basis for the plaintiff to unreasonably interfere with EKHO's right to the easement, nor should the court's ruling be construed as such. That's at the appendix at 79. And the defendants say in the brief, we recognize the importance of the easement and access for commercial purposes. And they inquire, what is it where exactly what we mean by unimpeded? And here's where I think the cases are sometimes in conflict. I'm going to urge the court to treat the phrase reasonably interfere as in shall not unreasonably interfere to mean materially interfere. Because in Tanaka, which cites Preston for the proposition that Preston didn't control that case, but then repeats the language of Preston. Those two phrases are used in the alternative. You shall not unreasonably interfere or materially interfere with access, right? So they're alternatives. And so I can fashion a whole series of hypotheticals where DLY could come in and say, what we're doing is reasonable. This whole case started with construction and scaffolding blocking the alley or arguably blocking the alley. We don't believe that a special warranty deed that contains an easement and therefore is by definition absolute, as we argue in our briefings, DLY doesn't contest, carries the kind of ambiguity or incompleteness that suggests that all kinds of reasonable tests should be examined every single time there's a potential conflict between, in this case, EKHO stage wanting to get access to the rear so it can do whatever it is it has the right to do in the easement, and DLY wanting to, for whatever particular reason, using that area of its property. But we agree with the general proposition that DLY retains its right to use the property. But when the judge says there are no restrictions, when the motions judge says there are no restrictions in the easement that imposed on DLY, well, that's exactly the opposite of what an easement is. It's as strong and absolute a conveyance of an interest in real estate as the deed transferring the property itself. So when my client pays $400,000 for an easement and the long history shows that it's for purposes of 24/7 access and EKHO Stage testifies that they don't control when trucks arrive or how big the trucks are or anything else, and they're running a 3,000 seat concert venue for which night times and weekends apparently are significant. We say that that what the judge had to say in his declaratory judgment ruling is not that there's no restriction imposed by the easement, that's clearly wrong. And that the intent of the grantors is irrelevant where the agreement is unambiguous, which I obviously disagree with. But he has to say that the limitation in DLY's action is they, under no circumstances can they reasonably or unreasonably interfere in the access that was granted by the easement. That's the clarification that we're trying to get here. And if you look at the cases there's not, that we cite, there's not exactly a straight line on that issue. So the shorthand issue has always been unreasonably interfere, but the flip side of it, or I'm sorry, but the rest of it has been, as in Preston, has been or interfere in any substantial manner interfere. And so, Your Honor, there was a case called Patterson, it came shortly after 6 years after Tanaka, and their phraseology was you can take whatever actions you want in your own property so long as you should do it without detriment. And then they say since the servient estate, the estate over which the easement is imposed, never effectively interfered, that's the word. And then they talk about materially interfering again. To me, the only restriction on the absolute right is so long as you're limited by true, not pretextual access, to interpret the words unimpeded and unfettered, is that where the interference is immaterial, insubstantial, then I think it's fair to read these cases as saying that that can't be the source of any cause of action, right? But anything else, and this goes to the interpretation of the language in the easement, which is maybe if you look at the last clause a bit on the awkward side in some places, right? This goes to the question of who wins. In a moment in time when both parties want to use the want to use the area on which the rights of easement are located. And it's true that 2135 or its assigns truly needs access for within the terms of the limitation to the rear and the loading dock, then who wins? And it's hard to determine that. If you look at both parts of the motions judge's ruling. To me, and what we're asking for is, to be blunt about it, the answer is we win in those circumstances, because unless the interference is immaterial, there's no point to an easement. If you say you have an easement to gain access to the rear, but you cannot interfere with DLY's right to use the very land or loading dock or rear of 2135, because you've effectively made the 2135 easement worthless.
I think
Even if DLY at any, any particular time, even if DLY at any particular time isn't actually intent on using it, you are still effectively interfering with their use.
I think we take your argument and let's hear from your colleague. Now we'll give you some time on rebuttal.
Thank you.
Good morning. As you know, I represent EKHO Events LLC, which is the tenant in this space. And the key
Can you
issue.
state your name for the record? Thank you.
I'm sorry, Stephen Metz, on behalf of EKHO Events LLC. And so the issue that was sort of the focus of the trial was whether it's EKHO Events LLC, goes by EKHO Stage. Whether EKHO Stage was using the loading dock, because the right of way, the easement document allows EKHO Stage to use the loading dock. And so, of course, the related issue, and perhaps even more important issue, is whether the Superior Court properly found there was no irreparable injury, because of course we were there only on the count for permanent injunction.
Can I just clarify the way you frame the question? Does that mean you don't think that what parking means is the question, because whether the trucks were parking or not, they fall within this broader right to access, to use the right of way during loading and unloading?
I'm not sure which way you're supposed to look at it as to what does parking mean versus what does using the loading dock mean.
Mm-hmm.
We've never asserted that we can park vehicles back there. Previously, before the DLY acquired the property, we were parking and when the easement was in place, because there was, I think, a 9-year period between 2010 and 2019. When the easement was put in place in 2010 and DLY purchased in 2019, we were parking there because their prior owner of DLY's property didn't have a problem with that. We would park buses back there, trucks back there. But when
When you say back there, you mean?
on the 2145 property, the right of way
Okay.
area.
Okay.
whatever you
Give me
wanna-
a little sense of what you mean by parking. Is it that it's there for a day, or are you storing a vehicle there long term?
So let me first make it very clear. We do not do any of those things now and have not done those things for years. But previously, a truck might sit back in the right of way area during a show, for example. Or employees of EKHO Stage would park their cars back there. Those things don't occur anymore, and there's no evidence that those things occur anymore. When DLY acquired the property and Mr. Marks, DLY's representative, communicated often with my client changed the way it used the right of way area.
Now, is there, just for my understanding, are there times when a truck will be there for 5 hours? But it's still active, loading and
So that,
unloading?
right, and so that was the focus of there were basically 4 instances that DLY presented at trial. And there are moments where a truck pulls up to the loading dock, and this is what the evidence showed. The truck pulls up to the loading dock. And these are what Mr. Cronin, my client's representative, testified as to. These were sort of the more, I forget how he put it, the more involved load outs or load in events. I mean, he basically testified there are some times when there are some quick deliveries where a truck just pulls up to the loading dock, everything gets put inside, 10 minutes later, the person comes out and then the truck's gone. But when they're preparing for major shows, a truck might pull up. This is what he testified to. A truck would pull up to the loading dock and there were bins and and rolling carts and things like that. Those things had to be moved inside, unloaded, and sometimes those bins had to be put back into the truck. The truck would then leave, and he testified that the truck never stayed there doesn't ever stay there during the show, right? So sometimes it would take hours to unload everything. There are trusses and lasers and cryogenic things and all these kinds of things. It would take hours while the truck was sitting there at the loading dock to empty all those things and put the empties back into the truck.
But you're describing something a little bit different, which, what I'm asking about is the times where you don't see people coming and going from the truck. They're inside doing something, right? Unloading, I guess.
So they're inside
Yeah.
unloading from these these bins and carts
For
and things like
hours.
that. Sometimes for
yeah.
hours, because Mr. Cronin testified, sometimes it takes that long.
Okay.
And then on the opposite end,
Counsel, I mean, what's a little frustrating about this case right now is I'm kind of wondering why y'all are here. If you actually agree, so I think, and I'll let appellee's counsel tell me this. But so far, your understanding of the easement strikes me as being entirely aligned with appellee's understanding of the easement. You can park a truck there during active loading and unloading. If you guys have that shared understanding of the easement, that sort of legal question about how the easement is best interpreted just goes away from the case. We can just write an opinion saying, that is what everybody agrees the easement means. It's during active loading and unloading. And then the dispute becomes, well, during all of these times that appellees are highlighting when a truck was sitting there for 4 to 5 hours, is that actually active loading and unloading? And when I get to that question, I read Judge Williams's order and I don't see an answer to it. I see her, you could read it one of 2 ways. At times she says, yeah, this is all part of the loading and unloading process, but it's unclear to me if she means a truck sitting idly between unloading and being reloaded is part of the loading and unloading process. It could sit there for a few hours until it's ready to be reloaded. That would certainly be a violation of the easement in Apelli's view. And I think maybe in your view, yes or no in your view?
Let me make it very clear. We don't think that a truck can sit there during a show after it's unloaded all of the trusses and lasers, all
Right.
that stuff. And then it has to leave. We don't take the position that it can sit there during a show.
Okay, so I think there's no debate between you guys, despite all despite all the legal wrangling about what the appropriate interpretation of the easement is. And so we're just in a factual fight of,
But
is that going on? And the question of is that going on does not strike me as being clearly answered here.
where the dispute is, I think it's slightly different from what you said.
Uh-huh.
It is because what I just said is not going on, and Mr. Cronin clearly testified it's not going on. What's going on is that the truck pulls up to the loading dock and it takes sometimes 4 or 5 hours before a show even starts to unload the contents of the truck in this expensive equipment, and then sometimes have to put the bins, pack the bins and rolling carts and things like that back onto the truck so the truck can leave, go park in this off-site space that was testified to, then come back the next day and basically do the opposite.
Yeah, but that's definitely your story. I'm telling you, Apelli's don't buy it, and I want to know. So you guys, I think, are totally simpatico right now. Again, I don't know why this took you all so long before the trial court. If you guys agreed upon the proper interpretation of the easement, the only question here, though, is whether or not that's what's actually going on. And like I said, I get that Mr. Cronin testified that's what's going on. Apelli's just don't buy it. They say there's no way that we're watching this truck for hours on end. Nobody's coming or going from it.
And part of that is because DLY has made it very clear that you can't basically, I'll call it, hang out on the loading dock. You can't really do anything on the loading dock during this period of time. So my client has been very careful to make sure everything goes completely in. Nothing is staged or unpackaged or unloaded outside on the loading dock. My client has been very clear, very careful to make sure, and he testified to that. Let's bring it all inside, do all of that in there, but they can't store the carts and the boxes and things like that. So that stuff has to go back onto the truck for it to be on the truck for the next day when they come and pick everything up.
That's not an issue for us though, is it?
Well, Apelli says that when their position, I won't put words in their mouth, but their position is that constitutes parking, and that doesn't constitute using the loading dock if they don't literally see somebody coming in and out every, whatever it is, 5 minutes, 10 minutes, 20 minutes, that you're parking there in violation of the easement, and we don't agree with that. And Judge Williams didn't agree with that. She did say on page 9 and 10 of her order, she was referring to, I think, the 2020 and 2021 events, and she said neither of these specified events, however, going on from 9 to 10 represents a violation from the court's perspective of the WFJD, as each activity was consistent with and contemplated by what is meant by using the loading dock. So I think she heard the testimony about at least I think she was referring to the 2020 and 2021 events and said that is using the loading dock.
And I agree that that's sort of it's that page 10 of her findings that it was there as long as it took to unload and load the delivery truck. The ambiguity I find in Judge Williams' ruling is I don't know if she means some hours of idle are included in the loading and unloading process. Like that's kind of, I think that's what the dispute is. I think the only disagreement, again, Apelli's counsel will get up and clarify if I'm mistaken. I think you all agree you can load and unload as long as you're actively doing so. And the question is, probably after unloading, the driver gets a bathroom break. Maybe he can go pick up a cup of coffee. Maybe he'll have 10 minutes of sort of padding in the loading and unloading process. I think what Apelli's are saying, though, is, these facts really suggest there are several hours of idling in between the loading and unloading. And maybe, Judge Williams said, no, that's not going on. I'm just not so sure. I think that sentence you highlighted is your best bet that she's saying that's not going on. I just kind of wish she had said it more clearly. I'm just not sure we have a clear factual finding on it. That's not really a question. I mean, I
Right.
agree. I guess I'd really, hopefully we're figuring out that there's not that big of a delta between you and appellees, and maybe we need to hear from them to figure that out.
I don't know if I want to hear anything more from you. Time is up, but
I mean, if you want to wrap up or if there's something.
I guess the only thing I'll add is that one of the other arguments that they make is that after we unload the bins from the truck, instead of having the truck wait there for potentially, well, let's say it takes 2 hours to unload from the truck, and then there's another 2 hours where we'll say it's sitting idly. They're saying, well, you should move that truck to this offsite place or to behind 2135. And I think the testimony was clear that is impossible logistically to move it behind 2135. So that can't be done. And that in terms of moving it to offsite, basically, Mr. Cronin, they can't control that. And basically that would be very burdensome and harmful to my client's business to tell these people, okay, go 2 miles away. I don't know how far it is exactly. Go over there, jog back while we do things inside, then jog back, get your truck. That's not how loading docks work. So I
Okay,
think
so now it sounds like you are saying that you're doing the thing that they're complaining about. A second ago, you're saying, no, we're not idling for hours. Now you're saying, yes, we're idling for hours, and we get to because it's too onerous not to.
No, I'm not saying we're doing what they complain about. We're using the loading dock the entire time. And I think that is what Judge William found based upon the evidence. Maybe she didn't say it as clearly as you're thinking she could
No,
have.
I think the question is whether or not idling counts as using it. Whether or not sitting for a couple hours counts.
I think it does when what they're doing inside is unloading from the things that came, unloading the packages that came off the truck and then putting the empties back on so that they can then leave during the show and then come back and do the opposite on the other end. Thank you.
Thank you.
Good morning. My name is Bradshaw Ross and I represent DLY. 40 years ago, when I sat in civil procedure in law school, I never thought I'd be standing before this body and discussing the meaning of the word park. But here we are. And I think your questions go actually to the heart of the case. And I would disagree slightly in that I think Judge Williams' decision was clear, but erroneous. When you use the word idle, she uses it 2 or 3 times to characterize the evidence. To me, the plain meaning of idle means not doing anything, being inactive. And the evidence was clear that those trucks remained there idle for hours.
But it's just the trucks that are idle, not as your colleague on the other side says, the people are inside still doing the unloading according to their view. Why is it only the truck? Like if they're, because the real question is this being used, rather than, I think is more important than whether you're parking.
Well, the truck is not being used once the material is unloaded and brought inside. The truck is not being used at that point in time. They're done with the truck.
Well, counsel, what your opposing counsel is saying is they're not done with the truck, that there's things that come in that then have to be stored back on the truck.
But there was no evidence of that. The truck was idle for 4 or 5 hours.
Mhm.
There was no finding, and there was no evidence that they were going inside.
No, there was definitely some evidence with the CO2 tanks that they were loading and unloading, and they said they had to come bring back the empties. I think I'm getting that. I mean, there's definitely some evidence on that.
Well, but there wasn't evidence that those tanks were being taken out at the same time tanks were being brought in or something else was being brought in. There was no active use of the truck at any time once the material was unloaded and brought into the building.
So
And
let
to-
me ask you, where would you draw the line? Like, I get 4 or 5 hours seems pretty extreme, but if we know we're gonna reload stuff on this truck, is it okay for it to be there for an hour, or does it need to go off-site And, as soon as it's gotten off site, sit there, the person has a cup of coffee and then drives it back and pulls it up again to get reloaded?
So I would approach that the same way we approach sort of our common life where we pull up in front of a store and we can't really park there because it says no parking, but we run in to get something real quick and we're standing, the car is there for a few minutes or whatever, but no harm, no foul, you're out, you're gone. At some point, the issue of reasonableness factors into the answer to your question. I think an hour is too long, okay? If you're done and you're not going to need that truck for another hour, then no, you need to move it.
But you would agree that we don't really have many clear findings at that level of specificity. from the
Correct, in
truck
terms
board.
of a time, no, but I would suggest to the court that the way to frame that answer is if the material is removed from the truck and it's inside, you need to move it within a fair, reasonable period of time, 5, 10 minutes, as you say, go to the bathroom,
So,
get a-
so what about you take in all these, um, boxes of things,
Right.
for lack of a better word, and they need to be unloaded and unpacked,
inside.
and that takes a long time.
Mhm.
And so really, if it's gonna take 2 hours to unpack all these boxes and then bring the boxes back to the truck,
Right,
because they don't want them there, they don't have room for them or whatever. You really think they should leave and come back because it's,
if it's 2 hours, yes, that's parking,
okay.
that's.
But
parking.
it's also use of the loading dock. They're unloading, and they unloaded the things, they're they're taking them, unpacking them. It seems, why isn't that just sort of the paradigmatic example of part of the loading, unloading process?
Because if you don't draw a fine line between what parking is and use of the loading dock, then where do you draw the line? How long can they stay there? Can I show up in the morning and deliver my product and say, I'm going, leave at the evening but because I'm accessed in the dock.
And while they're doing that, what problem are they causing your client?
Well, in terms of interference with our property right, which gets to a slightly different issue in terms of, and this was, to me, was the more interesting part about this case, is I think this case presents an opportunity for this court to finally make a clear statement to the community in the District of Columbia that easement rights are to be respected and property rights are to be respected. And you don't have to show monetary damages if someone is misusing your easement on the property, which is the law almost in every other jurisdiction, clearly from the case laws that I've cited. And this goes to what we said was one of the errors in Judge Williams' decision, is that she didn't find injury. She found adequate remedy of law that we could file another lawsuit or get damages. And what we're saying to the court is no. When you're dealing with property rights, and particularly an easement, it's not incumbent upon us to quantify the damages.
So just so we have an answer to Judge Beckwith's question.
Yes.
Is the answer none, but it doesn't matter? No quantifiable injury other than, that one of our sticks in the bundle of property rights being able to use this and, is being encumbered.
Yes.
Okay, but nothing more tangible than that.
Nothing.
I take your point that it doesn't need to be more tangible than that. I just want to know
Yeah.
if there is anything more tangible than
No,
that. Okay.
my position, and I think it's supported by the case
Sure.
authorities that we've cited, that if you misuse your easement right, that by definition entrusts the court to exercise its equitable authority to prevent the misuse of the property.
And counsel, before we get too much further down the
Yeah.
road, I want to slightly change the
Sure.
scenario about the unloading.
Yeah.
Now, I understand what we've heard before is that everything gets unloaded and then it's getting unpacked and the truck may be there waiting or idling or parking as you're calling it. And then things come back onto the truck. And that, because it's a couple hours where it's idling there and nothing's happening at the truck, that's parking in your view.
Yes, sir.
If they instead decided to unload the truck piecemeal and open things up, load it out, and then pull the empties, as they were called, back in and unload more, so that during that whole 2-hour time action was happening at the truck, does that then make it not parking?
If they are continuously accessing the truck to facilitate they're unloading and loading of whatever material it is, be hard pressed to be complaining about it. But that's not what, of course, has been happening. But your point being is that if they're going in and out the whole time and unloading stuff and then bringing it back and loading it back. No, I can't complain about that because they're actively using, but we're here because that's not what's happening. What's happening is the trucks are showing up, they're unloading and they're leaving there. And let
I
me.
mean, again, just, sorry, I don't want to cut up your answer to Judge Howard's question if you're not done. Please.
Well, I just
continue.
wanted to add one quick point to that because counsel constantly refers to the concert situation. Please understand, and we made this point in our brief, there's two things that go on here. There's the concert, which Mr. Cronin was clear, we move the trucks once we move the stuff into the building. We leave. So they're able to do that. What we're really complaining about are the deliveries during the week. When repair people show up or weekly deliveries show up, those people are bringing the stuff in and they're leaving the truck there for hours on end. So there's two things going on here. The concerts, they say, fine. And well, you're about to ask me a question, but I want to make this other point because although you say you think that we agree on what the easement says, please bear in mind that what the owner of the property is asking is that you reverse Judge Rigsby or remand the case back to him for a determination that perhaps we can park. I mean, they pretty much say that in their footnote, that that's their ultimate objective, to get the case remanded back to Judge Rigsby and get another crack at trying to demonstrate that they have the right to park under that easement document, even though it says you can't park. So I don't think
I'm
we're.
not so sure it says you can't park. I mean, it says you can't park for any other purpose beyond the purpose of accessing and using the loading dock. I mean, the beginning of the critical clause is for the sole purpose of accessing and using the loading dock. And then it says that the permitted users of grantees shall not park on the right of way for any other purpose whatsoever, if I drop a little ellipses in that clause. I mean, this strikes me as a totally semantic point, though. I mean, what is standing versus parking? And I think the answer is probably you can park while actively loading and unloading. Or you could call that standing while actively loading or unloading. You know, either way, it strikes me as a totally semantic point.
Right, as long as you're actively using the truck or vehicle for the purpose of delivering material.
And that's where it strikes me that they, at least today, they seem to be agreeing with you. Although they kind of hedged at the end and said, well, actually being idle for a couple hours is also loading and unloading. And that seems to be, I think, where you two disagree.
We would, if we were in agreement, we would not be here today. The ultimate objective of the owner is to expand his rights under the easement document, contrary to its plain terms, to park the vehicle when he wants to park the vehicle on our property. And that certainly is why we're here today. So although I appreciate what the court is saying in terms of, is there an agreement on this? There is not an agreement. And
Well, there's certainly not an agreement about what's going on. I mean, I mean, that strikes me as a factual question for the trial court that I'm still not sure I have any answers on. The trial court says that the trucks appear to be idle for times, but she also seems to say that's because the guys are in there unloading stuff and then they come back and they're doing that all the while. So it's part of a loading or unloading project.
yeah,
I mean, one way of thinking about it is if I let my neighbor use my driveway to unload some IKEA furniture, I say you can use my driveway to load and unload any IKEA furniture, and then they, you know, take 20 beds into their house and leave their car there for the next day while they assemble it, or they're really unloading it because, you know, and then reloading the boxes in the truck the next day. Is that really using my driveway for loading and unloading? And I'm not
like parking to me.
I mean, yeah, I mean, it sounds a little bit like parking to me too. I'm just not sure if that Judge Williams tells us what's going on during those lulls.
Well, when you read the testimony, I don't think there was any testimony where any of the witnesses said that while the truck was there, idle, that there were people coming out, putting stuff in the truck and taking the stuff out of the truck. I think a fair reading of the testimony and based upon Judge Williams' decision, idle means idle. Nothing was going on with the truck. There was no active use of the loading dock. the unloading process had finished and the truck stayed there for 4 or 5 hours regardless. And all we're asking is that stop. And we spent 3 or 4 days of evidentiary testimony on this issue before Judge Rigsby, and he was quite clear in his findings that the easement prohibits parking, even temporary parking. He was careful to emphasize that word, temporary parking, because the argument you're suggesting, or the scenario you're suggesting, was something that the other side argued vigorously during the PI hearing. And Judge Rigsby rejected it and said, no, parking means no parking, temporary or otherwise. You're done unloading, you need to leave. That was the agreement under the easement. And so, and since we're on that issue, I should just quickly, since my time's running out here, the relief that the owner's seeking to remand for unfettered or unimpeded access. Remember, please, that was the whole issue with the evidentiary hearing on the PI for 3 or 4 hours. They presented testimony claiming that we were interfering with their use of the property, of the easement, excuse me. And Judge Rigsby rejected that and said there was no evidence that my client was interfering with your use of the easement. That issue was factually resolved.
Yeah. There are, tentative findings and a preliminary injunction hearing, but then there's a full-blown trial and we have factual findings from a different judge there. And so I just want to highlight the sentence that opposing counsel highlights from the findings. Factual finding, which we are quite reticent to disturb on appeal.
Right.
Any truck parked in the right of way was there for the limited purpose of, and for as long as it took to unload and load the delivery truck. Your reaction to that finding is what? That it's clearly erroneous? That it's ambiguous because it's not clear what she means? What's your reaction to it?
That is, we cited that in our brief, I think, as the central error in her decision.
That's a clearly erroneous factual finding.
Or
that it's infected by a misunderstanding of what it means to use to load and unload because it includes too much idle time.
Yes.
Okay.
Both,
Okay.
both, that she did not follow Judge Rigby's interpretation of parking and what parking means. And that she allowed the period.
I don't know why we care about that. I mean.
Plus, he didn't really say what parking meant.
That's true. But again, we all go to the dictionary. We all know what parking means in our daily life. When we drive our vehicles around and leave them, we know when we're parking or when we're just temporarily running in and doing something and coming back out. You know when you're parking, you're leaving the vehicle, you're done with the vehicle for now, you're doing something else, and then you're coming back to it. But what you quoted, again, was we focused on that in our brief. We think that finding was erroneous, both factually and legally, that there was no evidence that those trucks were being used on the two bookends of unloading and loading. There was no evidence that the trucks were being used during that period of time. And to the extent that she found that to be factually correct, there was no evidence in support of it. And to the extent she makes that finding for purposes of interpreting the word park, it's an erroneous finding as a matter of law based upon the common usage of the word park. No more questions, I'll sit down. Thank you.
We will give you a couple minutes on rebuttal, each of you.
I agree with my friend, Mr. Ross, that I didn't take a course in parking in law school either. But this court has addressed parking issues over and over again. Neighbors fighting over split driveways, bowling alleys that require tenements and whether or not parking applies to one or the other. And our courts have cited DCMR on the definition of parking. So it comes up a lot because it's the kind of dispute, both in residential and commercial areas, it becomes a point of conflict. So I think there has been ample opportunity in the past to figure out that, one, we concede, parking is not necessarily loading and unloading. Loading and unloading has a definition that doesn't necessarily incorporate parking. And the party asserting that loading and unloading includes parking as a heavy burden to meet in district going on the case law, which would be Steinkemp, I'll give the sites if the court wants. They don't come up in the briefs. Steinkamp and Patterson and Penn are all cases that involve parking issues. We don't care. I'll say it again at 2135, and that's why I say if there's a remand, the first thing we're going to ask for isn't that the court go into great detail about what the nature of the rights of the parties are with respect to parking. 2135 doesn't have an interest. It may have an interest 8 years from now. Or if it sells the property, somebody else may have an interest 8 years. And we don't. There is nothing concrete or immediate about this issue as it related to us in the first place. We argued below that since the time we filed our motion for preliminary injunction, the parties didn't seem to have a lot of disputes. And whether it was the filing of the motion or the end of construction or whatever it was, one of our arguments below is, why are we here? We said below, when there's no immediate dispute, certainly not one involving us. Now, if Judge Rigsby is interested in proceeding further, then we're going to insist, as we said before, that the language in his decretal provisions of his order have to match up the underlying sentiment or the underlying agreement that there will be no interference by DLY with our right to access the rear of the property at 2135 of the loading dock, except, as I said, de minimis interference, because that is the alternative language that was used in Tanaka when it cited Preston, and a whole range of other cases say in various ways the same things. We cited cases saying that easements are by their nature provide for unimpeded interruption and certainly special warranty deeds too. So if we have that agreement, to return to the point of the panel, if we have the understanding that the council came very close to conceding in his second brief that we recognize the importance of access, and we have said, DLY have said, we won't unreasonably interfere. And the judge said, my order doesn't provide for the right to unreasonably interfere. And unreasonable doesn't open a whole range of considerations and some balancing test about the relative benefits of the construction that DLY wants to undertake versus the extent material intrusion of the right of access. As long as unreasonable means immaterial or de minimis, then we don't have a disagreement either, but that's not the way the decretal provisions of the declaratory judgment.
What do you think, if we thought that Judge Rigsby was correct in granting summary judgment on count one, because there was no genuine issue of material fact, but that he was incorrect in the way that he understood, that his statement about there are no restrictions on DLY's use of the easement. If that's what we thought, what do we do?
Well, you could remand with instructions to delete the decretal provisions of the order and leave intact his statement about unreasonable interference is not available to DLY, with the understanding that unreasonable means de minimis or something to that effect, or ineffectual interference.
And would that have any effect on the permanent injunction ruling?
No, that I can think of. Although the Judge Williams deferred her hearing on preliminary injunction pending the outcome of the motions for reconsideration, and it's clear that she didn't make any attempt to challenge or change Judge Rigsby's ruling. In fact, the only thing I could say it would do is would make her ruling stronger. If the end result is those portions of the declaratory judgment ruling that seem to immunize DLY from some kinds of conduct is now removed, and it seems to me it doesn't. If anything, it supports her ruling because it lessens the strength of DLY's position. But we have two different things, as counsel pointed out. There's what we can do, and we don't have, we meaning 2135 don't have a role in parking. And then there's what DLY can do to, quote, interfere with our right to access. And I guess it depends on which ones of those two columns of activities we're talking about. The last thing I would say is on parole evidence, there was a decision 2 months ago after all the briefs were written on parole evidence. I think Judge Howard, you were on the panel.
Mhm.
And so since it came after the briefs, I would just make mention of it because it does have, I thought, a comprehensive, short description of when parole evidence is applicable and when it's not. LUO versus District of Columbia DES decided February 27, 2025. Your Honor, I have nothing further, but thank you.
Thank you very much. Mr. Metz, we will give you a couple minutes as well.
Thank you. I'll just address a few points that came up with Mr. Roast. First of all, I think Judge Beckwith, you asked what problem is, echo stage potentially causing? And the evidence showed no problem. There was basically no burden, even during the long times that a truck may have been sitting at the loading dock. And if you look at page 120 of the transcript, when I was cross-examining Mr. Marks, I said, there's space to the left of the truck, at least in one of these situations. There's space to the left of the truck in these pictures, correct? If you needed use of the loading dock. The answer, right. For the 5 hours they were there, I can't say that we had somebody who needed to use it, but it's our property and we don't want people parked there. We know that's his position. So there was no evidence to show any burden, even assuming there was some violation.
Does that matter though? I mean, as you said, his point is defending one's property rights is defending one's property rights. Does there have to be a burden?
I still do think there has to be a burden.
Well, I mean, if somebody parks in my driveway and I tell them to get out and they say, well, what, you don't need to use it now. Do you think that's a good defense? Or who do you think's in the right in that dispute?
Say that again.
If
Sorry.
somebody parks their car in my driveway and I
Right.
say, get the heck out of my driveway. And they say, well, you don't need it right now. And I say, yeah, I don't. I just don't want you here. Who do you think's in the right in that dispute?
Oh, I think the owner of the property is in the right
Right.
in that case, but here we've got an easement that allows us to
Well,
use-
but,
use. we
the
have a right
premise
to
of
be-
the argument is if he's right that you're not allowed to be there, he doesn't need to show an additional infringement on some property interest. I mean, that I think you would agree. If he's right, that you can't be there, the fact that it's not encumbering his use of the loading dock,
Yeah, that-
doesn't matter.
Right, that's certainly not our strongest.
Okay,
That's not-
good enough.
I'm not gonna, whatever the phrase, whatever. So there's that. And then you were talking about the process when trucks pull up and you were asking Mr. Roast about whether there was evidence about that process. And there certainly was. On page 178 to 180 of the transcript, Mr. Cronin, and I'm questioning Mr. Cronin, and I'm asking him, let's talk about, when you just described items are taken off the truck to move inside and the empty containers are, they stay inside, EKHO. Didn't speak very clearly. And they're not moved back onto the truck before the truck leaves. I mean, how long does that sort of process take if the containers end up staying inside? And he answered, basically said, just unloading the containers can take hours and hours of loading because it's specific pieces that have to go in order, be connected at the proper time. They literally get pushed up into the stage by stagehands in order so that it's not just all clustered in one place, everyone's running around, anyway, so he goes and talks about the process of unloading and how that can take sometimes many hours. And then I asked him, okay, on the top of page 180, I said, okay, and then in situations where the empty cases have to go back into the truck because they can't stay for whatever reason, how long does that process take if you can generally describe that? And he said hours and hours, but again, I would specify that when the cases stay inside the venue, that truck leaves the venue. We're talking about the next day, usually these are loaded up. So he was talking about the different situations. Sometimes the cases do stay in, and so the truck just leaves, and sometimes it takes hours to put the cases back into the truck. So there certainly was evidence of that process. That was one of your questions. Judge Howard's question as to, well, change the factual situation a little bit. Let's say they're, doing something, on the loading dock instead of what I said has to happen because DLY made it very clear. You can't basically do anything on the loading dock other than walk from the back of a truck to inside or from inside to the back of the truck. But I think your question was telling, why should it make a difference whether they're doing those things literally outside on the loading dock or inside? It's all the same process of using the loading dock. And DLY made it very clear, and I think that's in the testimony, that you can't do anything on the loading dock other than walk back and forth. So everything's done inside.
Well, I think, counsel, my question was slightly less about doing it on the loading dock. You seem to present that there was some virtue in the idea of unloading the truck entirely and then not on the loading dock, but inside, putting everything together and then unloading the empties. And the trucks could sit there for hours during that. My question was, well, what if you did it container by container, so that there was minimal time between containers going and we empty one container and we bring it back? And I thought it was just as telling from perhaps your perspective as well.
Right.
That wouldn't be an issue because there was activity going on. And I'm not sure there's a great difference between those two things.
I don't think there is. I think I'm understanding it. I don't think there is a difference, and it shouldn't make a difference. And then Mr. Rose made a comment, and I know he wasn't trial counsel, but he said that basically what DLY was complaining about is the weekly deliveries where trucks would allegedly be sitting at the loading dock versus the concert deliveries. And I don't think that is what they're complaining about. They're complaining about the hours that it takes when deliveries are being delivered right before a concert, where it sometimes takes hours to unload and then may take a couple more hours to load the boxes back on. And then the truck again leaves before the show starts, does not stay there during a show. I think that evidence at the trial was very clear that deliveries during the week, like let's say, I forget what Mr. Cronin used as an example, but he did talk about it in his testimony. And I think he referred to it as day-to-day drop-offs being quick, not laborious. If somebody's delivering, I don't know if you said, let's say water jugs or something like that, it's pretty quick. The truck driver just takes the stuff inside, comes back outside and leaves. Doesn't take a long time. So I think what they're complaining about is the prep for the shows, not the sort of the weekly quick deliveries. And there are no lengthy periods of time when a truck is at the loading dock during the week. It's all either in preparation for a show or after a show when they're removing the trusses and lasers and things like that. That's it. Thank you.
Okay, thank you very much. Thank you to both sides for your arguments and your briefing. The case will be submitted.
Thank you. Thank you.
Second case on this morning's calendar is number 24 CF 48, Luis Rivera versus United States.
Morning, Your Honor.
Morning, Mr. Haslip.
I'm Tom Haslip. I'm here for Luis Rivera. And I want to start with the corruption bias issue. And I want to say that in this particular case, you had somebody throwing objects at or over a police line, and you had 2 police officers being hit. But you also had a lot of other people throwing objects over or at the police line at more or less the same time. So one of the government's things that they had to do, and really was probably the most difficult thing, was to coordinate the tosses that they have on the body worn camera from Mr. Rivera with the strikes against the individual police officers. And they did that by using the timestamps, more or less, on the body worn cameras. There wasn't any one of those body worn cameras that told you the whole story. It had to be pieced together. The person who did that was Detective Babbage. And he did it over, apparently, it took 3 years for this to actually ripen into a warrant, or almost 3 years. So from the defense point of view, in this case, the point would be to make the jury mistrust the body worn camera footage in terms of the timing of it, and therefore mistrust the idea that the things that were thrown by Mr. Rivera actually hit the officers that are named in the complaints, or the indictment in this case. So
as to Babbage, the thing that you wanted to get in was that he had been disciplined for sending a text message to somebody complaining about another officer talking about the events of January 6th, expressing some concern that, you know, the body worn camera wouldn't back up the officer's account. So is that right?
well, there's that, and there's also the, let me quote this, risked revealing unsanctioned police practices. In other words, by talking to the press, the officer risked revealing unsanctioned police practices. Now,
So who's Officer Babbage sending this text message to?
I don't know, some civilian.
My rough sense was, I don't know, some civilian.
I mean,
So I guess, I mean, to me, what's the corruption bias? You know, if he had contacted somebody and said, you know, shut your mouth, you're revealing bad police conduct, that strikes me as corruption bias. If
yes,
he's
and that's
talking,
more or less what he's doing. He's complaining that the guy could have kept his mouth shut because he could have revealed unsanctioned police practices. And it's the sort of the same thing. It's just that there's a little remove there.
I don't think it's sort of the same thing. If I tell my friend, I don't like what this guy's doing, he should shut his mouth. That doesn't really seem like it has any chance of interfering with some official proceeding or influencing that other individual. That's just me blowing off steam to my friend.
But it does show an attitude on his part to want to hide things in terms of police practices. And in fact, you know, here we have the guy, this is the guy who was central to the whole case, really. And here he has control of these things. He testified that they are to the inviolability of the body worn camera things. He testified to the accuracy of the timing. And if the defendant could show that he was untrustworthy and that he had an attitude which would allow him in this other case to want to hide unsanctioned police practices, that might affect the jury's evaluation. The judge dismissed it, but it was the jury that was supposed to evaluate that. And I don't see, I mean, if there's an arguable case that you know, there's bias there, corruption bias, that's the jury's business, isn't it? It's not the judge's business. I don't like that case. And so I'm not going to let the jury hear that. I mean, I think she was too influenced by this looking at the body worn camera stuff, but the possibility, and the defense lawyer argued about it because there was this gap, this 11-second gap. It's not like the time stamps were absolutely accurate. I mean, that was demonstrated at trial that they were not accurate. So the question is, if that one's not accurate, why is it accurate that at 8:49.6 he throws this, and at 8:49.6 or 7 this guy gets hit? Why is that accurate? It may not be accurate because this detective might have messed with it. It's possible to do that, as you can see, by the virtue of the fact that there's this 11-second gap. This is all argued out in front of the judge, and she just couldn't see how the jury might mistrust this guy. And I mean,
Sorry, and I know you already answered this, but remind me what the text he sent was again? I mean, I found some of this quite unclear in the briefing, and I couldn't get clear answers from the record either, so The text is, can you give me where can I find it? Is it in the record or is there?
It is in the
some-
record. The government put it in the record and it's on a CD disc that I have in my file, but I can't show it to you now. But all of the stuff,
Uh-huh.
the more particular area is in that supplemental addition to the record, if you want to look at it. But I mean, you have pretty much in the transcript, you have more or less what this is about. And it is arguably an instance that shows that this detective wanted to hide.
So give me the closest, paraphrase it for me.
I'm sorry,
What do you
what?
think the text says?
It says risk revealing unsanctioned police practices.
Uh-huh.
And I think my understanding of it is there was this guy was undercover and he was carrying things that he shouldn't have been carrying as he was undercover. And, that's an unsanctioned police practice and could just expose this and that. But I think it just, and there may be an explanation, a reasonable explanation that doesn't involve corruption bias, but that's not for the judge to decide if it's arguably shows the corruption bias. It's for the jury to decide. But they didn't get to hear it.
Can I see, the government says that you abandon your claim about the form of bias of currying favor because you really just kind of described it in your brief but never made an argument about it. Are you still pressing the claims you're making about the officers who had various ways of being shown to have curried favor?
I don't see the currying favor as a particularly strong. I mean, there was one fellow there that the judge gave an instruction that she probably shouldn't have given, but
You're sticking with the corruption bias primarily.
right.
Okay.
That's right. That's because that really goes to the heart of how this case could have been won despite the body worn camera footage. When I was trying all these cases, there were too many body worn camera cases, but now there are, and they're all there. And this detective was the detective who vouched for the accuracy of what he had handled and put together in terms of getting the arrest warrant in this case. And the jury should have been able to decide whether he was reliable in that based upon his, you go to these police boards and you get suspensions and it can be, his penalty for what they actually found was kind of light. A 5-day suspension that was suspended, a suspended suspension. But nevertheless, that's not what they were, what the board did had to do with a technical violation of speaking to a citizen about an ongoing investigation. But what this detective showed in his text was that he was arguably a person who would try to protect unsanctioned police practices. Wouldn't want them, and therefore he might be the type of person who would alter the timestamps on the body worn cameras. I did have a second thing about the
Well, can I ask you more about the cross-examination? Can you talk more about why it's not harmless? You say in your brief that it's the testimony of these officers is not cumulative, but why isn't it cumulative of the parts where they're describing, the body worn camera, what's being shown on the camera?
because none of the witnesses are able to say down to the last 10 or 20 seconds what's on the body worn camera. In other words, they're looking, this is after 3 years, they're looking at their own body worn camera thing, and they're taking the timestamp as the timestamp. But it might not be the accurate timestamp. And the guy whose body worn camera did have an inaccurate timestamp had no explanation for that. And it was never explained. And the question then is, why? I mean, it's not harmless because it goes to the This is a case that came by piecing together body worn camera things and timestamps to show that when he threw the object, it hit this guy, Berghoff and the other fellow, right? And without that timing, there's no way to show that, because as the evidence also showed, these metal objects were all over the ground in back of the police line. Lots of people were throwing them. And if
But this
Mr.
wasn't really a part of his defense, right? His defense was ID, miss ID.
I don't, I mean, there wasn't any defense. I mean, they didn't put on any witnesses, and they just attacked. And he wanted, I mean, there's a long passage in the transcript where he lays exactly out what I'm telling you now. And the judge says no. But she does say, I can see why you're doing that, and it's an issue that you should pursue. And now we're pursuing it. And it's just, to me, it's just a judge usurping the function of the jury to decide the credibility of basically the central witness. The other police officers, I mean, you can say, for instance, if I turn my body worn camera off when we're about to get into a fracas, that seems to me to be a pretty good example of not wanting what you're going to do to be public, not wanting it to be documented. And that there are a lot of these instances, and that also falls into corruption bias unless it's explained. And I think that, to be honest, if you're trying the case from the defense point of view, you want as much of that, you want as many police officers, the veracity of those police officers questioned as you can. But the central one was the detective who had control of the evidence. And before it was submitted to the U.S. Attorney's Office and before the warrant was made up. That seems to me to be the central point. And the point was made by the defense lawyer in the arguments about whether this came out, and it didn't. In terms of the instruction, there's no intended victim here, and you shouldn't be talking about it, right? After the jury asked about them. I mean, in some ways, the jury is curious about whether you have to show he intended to harm these people. But
Well, I mean, what the jury asked was, did they need to show that they intended to harm the specific individuals who were hit? And what do you think the correct answer to that question was?
I think I put it in a brief. The correct answer is, if you threw the thing intending to harm a police officer, and then the correct victim is the person that it hit.
So you think the answer is yes? The answer to that question?
In some ways, yeah. I mean, they don't have to show. They have to show that he threw the thing, that he threw it intending to harm a police officer, and that it hit this guy. That's it hit this guy. I mean,
It hit the intended officer, you think is
the whole group of police officers and charge them one by one.
I mean, there are definitely cases where we've upheld assault convictions where somebody, swings at person A and accidentally hits person B.
Oh, yeah.
So why would saying yes, they needed to intend to hit the specific individual be a correct answer?
Because you're confusing the jury. When you have a case where somebody throws at a police line, and not intending to hit any particular police officer, but like to intimidate the police or to inflict harm, in some way, and then you start talking about substituting the person who actually got hit for the intended victim, that's just confusing, and it shouldn't have been put in there. You should have just said it straight up. I don't know if it made a difference, to the verdict. The verdict came pretty quickly after that. So, but I really want to talk about Babbage and the corruption bias. All right, I actually have some time left.
Thank you. We'll give you a couple minutes on rebuttal.
Morning, Your Honors, and may it please the court, Dylan Always for the United States. Trial court here did not commit reversible error either in its limiting instructions on cross-examination on Mr. Rivera's proposed cross-examinations of the witnesses here, or in helping to clarify any jury confusion in response to the note here with the supplemental instruction that was delivered. We'll start here with corruption bias, which is where appellant started, and specifically with respect to Detective Babbage. Judge Deal, I think you hit the nail on the head here when saying that this is a text message to a third party. That does not sound in the types of corruption bias cases that this court has found where a proffer, which is the defense burden, the burden of the proponent of the cross-examination to carry a trial based off the proffer below. As your honor was well aware in your confusion, where was the proffer here on this specific type of theory of corruption bias in the record that was put before the judge? And I'll direct your honor's attentions to the quite lengthy discussion of the case law about corruption bias in Smith. It talks about how the types of bias, the types of activity that support corruption bias is not just, the proffer has to show it's not just about a witness's veracity, but an actual corruption of the truth-seeking process at trial. And so it is things like blackmailing witnesses. It is things like tampering with evidence. It is things like manufacturing a fabricated confession. That's the Coates case. Witness tampering and witness coaching, that's the longest case. Blackmail, bribery, that's CBN. Texting a third party to complain about a media appearance has nothing to do with corrupting the truth-seeking evidence at trial.
I don't mean to take you off of Officer Babich for a moment, but I'm just curious why you think Officer Rodriguez's, the testimony they sought to impeach him with wouldn't fit that mold. That was leaving the scene of an accident. That strikes me as subverting the conduct that seems on par with being willing to subvert the law in a very direct way. The testimony, I think the evidence that they wanted to use to show Officer Rodriguez's corruption bias was something like he sideswiped a car and then he drove off. That's pretty bad. He I guess came back when he got some wind that he had been spotted. That all seems I mean, it's not quite as bad as coaching witnesses or witness tampering or blackmail. It seems to be of that general variety though.
So in evaluating the proposed cross-examination of Officer Rodriguez, I think it's important to focus both on the theory advanced below as well as the complete factual proffer that was put before the judge when she was making the determination here. So the theory that the defense raised below was not corruption bias. It was about credibility and reliability only. And they never tried to articulate a reason why this would be corruption bias. So that's what was before the judge in making this decision. But putting that aside, the full factual circumstance that was put before the judge was that the Officer Rodriguez was en route to a priority assignment, right? Lights and sirens were going to a crime scene. He sideswiped a vehicle. And when he was done with that crime scene, responded right back to the location where this was. That was all put before the judge. On abuse of discretion review and determining whether that factual circumstance shows that this is someone who is not just a propensity about veracity, but a propensity to corrupt the truth-seeking process at a trial in a judicial proceeding, the judge was well within her discretion to say, on this factual basis, I don't find that this is someone along the lines of, again, blackmail, witness tampering, fabricating a confession, to say that this person is shown that they will corrupt the truth at a trial, that they will lie under oath, that they will manufacture evidence, that they will completely subvert the truth-seeking process before the jury or in a judicial proceeding.
Does the judge need to make, I mean, isn't the question for the judge whether or not a jury could conclude that this is somebody willing to undercut the truth-seeking function of a trial? I mean, there are two very different versions of those facts you could take. One would be, he always meant to come back. He left, he was on a priority assignment. Another one, I think that the defense was floating was, no, he had gotten wind that he had been spotted and that's why he returned. And a jury could go either way with it. And I think if they thought the latter, that he wasn't intent on coming back, then they would think, well, yeah, that's a guy who you really couldn't trust in an official proceeding. This is somebody who seems willing to, obstruct justice, for lack of not exactly that. I don't think it would fit the statutory definition, but something like it.
Akin to obstructing justice. And I don't disagree with the way that you put it, right? So the judge has a gatekeeping function to make sure that this proposed line of cross-examination would fit within the theory of whatever they're seeking to use it for, right? So here it was credibility and veracity only. They don't press that on appeal. On appeal, they substitute that for corruption bias. And yes, the judge would have to be able to determine whether a reasonable jury could find corruption bias on the facts proffered by the defense here. But as Your Honor was stating, this is corruption bias is akin to obstruction. Coming back to the scene, the full factual proffer here about coming back to the scene and self-reporting, a judge would reasonably be able to find that that wouldn't, even if they had advanced a corruption bias theory, that wouldn't necessarily fit what this court has delineated as far as the types of activities that support a proffer to be able to get into corruption bias along the lines of Coates and Longus and CBN. I'd also like to put in context what Officer Rodriguez's role was in the case.
Right, and I thought you might start, I thought you might try to, I appreciate you not dodging my questions. I mean, I know where you're, please.
But yeah,
Go ahead.
Officer Rodriguez was simply there to say that was my body worn camera that you had. He corroborates what Detective Babbage had said here, but plays almost no role in identifying the defendant as the assailant. He simply said, I was wearing my body worn camera that day, and that was a recording that happened there. He has nothing to do with the timestamps as he testified.
Can I ask you about a couple of the officers where the claim involves their, actions taken up with respect to their body worn camera? You say in your brief that these body worn camera activation issues don't reflect the type of misconduct like bribery, blackmail, witness coaching, witness tampering, and manufacturing evidence that typically underlies this type of corruption bias, I guess. So is that a fair statement? Like, do you mean it's sort of different in kind or different in degree? And if if you have a situation where you have like a sustained misconduct finding that an officer, beat a false confession out of a suspect, I think you would agree that should come in as corruption bias.
Yes, I agree.
And what if the officer also, deactivated his body worn camera right before that, assault occurred? Is that, a technical minor violation, or I'm just getting at your description of these deactivation violations as sort of different from real serious stuff?
Of course, and allow me to clarify, it's not a categorical approach. So all of these proposed lines of cross-examination are fact-bound, and they're based off of the proffer that the proponent wants to put forward before the judge to support the theory of bias here. So in the hypothetical that you gave is a far more comprehensive articulated theory of corruption bias, where you are putting forward a well-reasoned suspicion that this officer is not only engaging in this type of misconduct of beating a false confession out of someone, but affirmatively trying to hide his tracks or his or her tracks by deactivating the body worn camera. All of that is a well-articulated theory to say, yes, we should be able to get into the types of corrupt activity here to thwart the truth-finding process at trial. But focusing on the facts in this case, there's nothing that reasonably approaches that, or reasonably approaches what the types of proffers that this court has found sufficient, but also what this court has found insufficient. For example, in the Smith case, Smith involved a Gerstein affidavit, sworn testimony submitted to the court in order to establish probable cause, that in many ways or materially differed from what eventually came out in an IAD investigation. And even there, this court drew the distinction between the types of cases with witness tampering, blackmail, manufacturing of fabricated confession, to say, well, you know what? No, this actually doesn't support a well-reasoned theory of corruption bias there. What Your Honor just articulated, I do think is different in kind from what is before the court here. And again, what is before the court here for Officer Burgraff, they've conceded that they wouldn't be able to get into that body worn camera violation below, and conceded it again on appeal. For Officer Motley, they never articulated any basis for why they should be able to get into cross-examining him about these body worn camera violations, other than saying he had body worn camera violations. And for Officer Boone, again, they press this only as a credibility theory only, never as far as corruption bias. They sort of abandon that theory and press corruption bias here on appeal. But again, the facts there don't support this well-reasoned suspicion of not just credibility or veracity, but a willingness to subvert the truth in the trial.
So do you think there has to be a really well factually developed theory in order to rely on that kind of evidence for a corruption bias theory? Or, you know, like why, there's sort of some question about why would an officer deactivate in the middle of, you know, you might not have the facts to support what you've said, seem to be okay in my hypothetical, but, you know, does it have to, how thorough does the record have to be on that?
It has to be thorough to be able to support the specific theory that they're going after. So as we cite in our brief, the Ashby case says that it is the proponent that has to proffer facts probative of that theory of bias, facts or well-reasoned suspicion probative of that theory of bias, and that the burden is on that proponent. That's the Coles case. And I'll also point your honor to the Smith case, where they talk about again, a much more thorough theory of bias put before the court, and even said, based off of that theory, even then, cross-examining on a corruption bias theory about discrepancies between a sworn Gerstein affidavit and facts that were put before the IAD board, even then, that doesn't support the types of corruption bias that this court has said would go into it. That's not to say that it wouldn't support other types of theories of cross-examination, like credibility and veracity, which the Smith case drew a sharp distinction for and said you can go forward on that, but that's not before your honor in this case. They're proceeding solely on a corruption bias theory that was never articulated below. I don't need to reiterate all of the reasons why this is harmless, but we'll briefly say that this case was built on objective evidence. Officer credibility, despite the way that the appellant is categorizing this, was not really front and center in this case. And that's because we had multiple different objective sources of evidence that corroborates what the officers were testifying to. Many different angles of body worn camera video.
You know, I haven't tried to do this, but I think you're trying to say something like the following. If I ignore the timestamps and I just look at the videos and kind of cross compare, there's a lot of videos. Like I said, I haven't tried to do it. I don't know how this is going to pan out if I try it. But I think you're going to tell me where you're going is that I will see things match up. You could attach any timestamp you want to them. It's all going to line up if you know, on some close scrutiny, and there's no reasonable probability a jury would have been misled about that.
That's correct. You can see the angle in which the projectiles are coming from, where they are landing within the crowd as they are going over officers' heads and eventually landing on these two officers. You can also see the person who threw the projectiles in multiple different body worn camera videos, and the jury was in as good a position as any to be able to say, is that the same person who's sitting at the defense table in front of us? And not only that, they had the Miss Murray come in who knew the defendant, who identified him directly based off of the body worn camera video of a person wearing the same bandana and same shirt as the assailant in the case.
Can I take you on a total tangent that's really not relevant to the issues raised on this appeal? But you know, the jury is instructed on assault with significant bodily injury while armed, not guilty. A lesser included of assault with significant bodily injury, not guilty. And then it got straight to assault on a police officer. What happened? I mean, I just wonder what the heck happened to assault with a deadly weapon? Why wasn't the jury instructed on that? I mean, you see this footage. These are very serious. These are very heavy metal. I guess they're part of a bike rack or a railing. Tossed at people's heads. I guess I wondered, I guess the jury thought not a significant bodily injury, as it turns out, because there was a pretty slight gash on one shin and maybe not anything so serious in the other one. But why not? What happened to the simple assault with a deadly weapon?
So the instructions were related to the felony assault on a police officer while armed, which encompasses the creating a grave risk of significant bodily injury.
Mm-hmm.
So the finding, the ultimate verdict here was on the lesser included count of the misdemeanor, 2 counts of the misdemeanor assault on a police officer. I can't speculate as to what because
if the jury is going, the theory being that if the jury is going to reject significant risk of serious bodily injury, they have kind of perforce rejected the idea that a deadly weapon was used. Is that the rough idea?
That's, and
Okay.
there wouldn't be I don't believe that they would, the government was seeking the misdemeanor APO while armed here. So
Okay.
what they effectively, I think you can potentially infer from this verdict is rejecting that Mr. Rivera's actions were causing this grave risk of
Mhm.
significant bodily injury.
Okay.
And instead it is your.
Like I said, I
regular-
was just curious. I appreciate that explanation. That makes some sense.
I'd like to very briefly address the jury instruction. As Judge Passage, I think correctly interpreted the jury's question to be is, can we find that these officers were within the scope of intended victims here? And the concurrent intent instruction was well crafted to be able to address that. Now, as we state in our brief, it heightened the government's standard burden of proof here by going away from what this court has consistently held as a general intent crime.
I don't know how
to-
consistent we've been about that. I thought we tried to get rid of that. I thought we said in Paris Hernandez, stop talking about it like that. Maybe not. Maybe only with regard to offensive touching assaults is the government's position. Because I keep seeing it come up, and every time I see it come up, I think, didn't we get rid of that?
President Hernandez in talking about the model penal code for purpose and knowledge is discussing in the context of the non-violent offensive touching context. I believe as this court recognized last year in Ray GW, President Hernandez did not go so far as to say that we have ascribed the model penal code to other theories of simple assault, including here would be attempted and indeed completed battery assault.
Mhm.
But that I would submit that need not
Yeah, I
concern
don't
this
think it
panel
really
too
matters
much,
so
only
much here.
because the instruction here actually increased the government's burden. Juries are presumed to be able to follow that supplemental instruction. And so the government, in fact, proved the specific intent to injure and harm the officers here. As Judge Gil, as I think you mentioned earlier, this court has on several occasions at least implicitly adopted this concept of zone of harm on a regular assault, not specific intent version of assault charges. In EDP, which we cite in our brief, is about juvenile detainees trying to fight with each other and connecting instead with the officers that were around. That is effectively what the theory is that the court adopted here. Fletcher involves the concurrent intent of someone opening fire on a group of police officers. Granted, that was also involved the specific intent crime of assault with intent to kill while armed, but this court has recognized that that's a viable theory of assault to be able to support an APO charge here. So there's the error, if there was any, was increasing the government's burden of proof. But again, the concept of the zone of harm shouldn't worry this court about trying to help the jury to define what the appropriate scope of the victims are. And I will very briefly say that again, it's our position here that any error would be harmless for three reasons. One, it benefited Rivera by increasing the government's burden of proof. Two, the specific intent that the jury necessarily had to find in this verdict based off of the instructions includes the general intent to act that, again, we maintain is still good law as far as APO is concerned. And third is that the government was held to its proof for both the intent and the knowledge elements. And the evidence certainly bears that out. This was a group of police officers. There were no other civilians in the area in the line of these projectiles. That was consistent from the body worn camera and the witness testimony. Unless there are any further questions on either of the issues, we'd respectfully ask the panel to affirm the judgment of the Superior Court. Thank you.
Thank you, Mr. Aluz. Mr. Heslop, we'll give you a couple minutes.
Thank you. I just want to go back to Detective Babbage, where we have the judge going along. The thing that troubled me the most was don't admit to the media you're a plainclothes officer when you darn well know that's unauthorized and you're getting your supervisors out to dry, putting your supervisor. That's concerning, which is why they discipline. And then it goes on. Don't come if you decide to talk to the media. Don't admit you've never put your uniform on when you're clearly wearing pretty much all unauthorized equipment. I'm not even sure what that means, but it doesn't mean anything good or appropriate. That's what the judge's evaluation of the situation with Detective Babbage was. And you know, that's right. Doesn't mean anything good or appropriate. It means a willingness to subvert the rules or to condone a subversion of the rules, as long as it doesn't get public. And that really, that's where we are here. It's in terms of the not returning and all, I mean, pretty clearly, that's a problem, and it should have been allowed to be explored. I don't know, given the nature of his testimony, whether I could really say, well, it's important, except for if you start to stack these things up. This guy turned off his body worn camera. This guy turned off his body worn camera. This guy didn't, you know, had a hit and run, right? And wasn't going to go back until he got caught. And this guy doesn't want this undercover officer is wearing bad equipment, doesn't want that to come out. And is willing to complain about it, willing to subvert the rules. All of that, if you stack it up, you know, it could be effective. Clearly, some of this should have been. I mean, the thing with turning off the body worn camera before there's this fight on the street, that's one thing. Thing about the auto accident, that's another thing. And the Babbage thing, that's another thing. Some of the other body worn camera stuff, you just have to ask yourself, how am I supposed to know what exactly it is? Why does the police officer ever turn off his body worn camera during when he's performing his function? And maybe you should be able to ask that police officer that question.
Can I just, to make sure I understand the facts correctly, I thought the violations we were talking about was the failure to turn on the body worn camera. Is it actually turning it off in the middle of something? Or-
Well,
those two strike me as quite
when you're
different.
out of the car, you're supposed to turn it on. He didn't turn it on, and then he got into this fracas, and he turned it on after it was over.
Okay.
And
I think it's a little different to my mind in terms of what you can insinuate
I
from it,
think
the
that's
failure to
right. I
turn
think
on.
there was an earlier, but I don't know exactly when, but earlier, I mean, you know, as it happens, I've just gone through looking at a lot of body worn camera stuff, and you know, you just have to hit it to turn it on and off. And so it seems to me that they're all used to it, and when they turn it off or don't turn it on, that's an intentional act, and you should be able to ask them, why did you do that? What were you trying to hide? Anyway, with that, I ask the court to reverse the convictions.
Thank you. Thanks to you both for your briefing and your arguments today. The case will be submitted. The final case on this morning's calendar is number 23 CV 897 EAB Global Inc. versus District of Columbia. Whenever you're ready, counsel.
May it please the court, Cynthia Gerhard on behalf of appellant EAB Global. May I reserve 3 minutes of my time for rebuttal?
Sure.
Thank you. The issue in this appeal is whether appellant EAB Global can be denied access to the courts to seek redress for its breach of contract claim against the district when it has no other alternative remedy. Superior Court dismissed EAB's complaint on the grounds that the Anti-Injunction Act barred its claims. The Anti-Injunction Act states that no suit may be filed to enjoin the assessment or collection of any tax. However, the Anti-Injunction Act should not apply in this case for at least 3 reasons, each of which independently support reversal. The first reason is that the Anti-Injunction Act does not apply where the plaintiff has no other remedy for its alleged injuries, as is the case here. Second, EAB's complaint does not seek to enjoin the assessment or collection of any tax. And third, even if the Anti-Injunction Act did apply, an exception exists. So first, going into the first element, that there's no other legal remedy or available remedy to EAB. Both the Supreme Court and US Circuit Courts and District Courts have held, looking at the Federal Anti-Injunction Act, that the act was never intended to apply to scenarios where the party would have no other redress. So the typical application of the act would be in scenarios where it is a taxpayer, here EAB is a renter. So typically it's where a taxpayer might file suit complaining about an assessment of their property, something of that sort, and the court says, no, we the legislature has created an alternative. You first pay your tax and then you go seek a refund through this alternative. And that's what the district is asking EAB to do here, completely ignoring the fact that that remedy is not available to EAB. So EAB.
Well, I mean, it might not be available to EAB, but it's available. There is a refund suit that could be had by the property owner, right?
Yes and no, even if, so first, the Supreme Court has held that the Anti-Injunction Act still is not intended to apply in that scenario because a party should never need to rely on another party to assert its claims.
Yeah, see, I don't know if that sounds like, I mean, I'll have to, what case do you want to point me to? That's a South Carolina case you think holds that?
Yes, Your Honor, South Carolina.
So let's say that me and my neighbor, through a very clever scheme, assign to one another we trade tax, it rights to any tax refunds that we get from property taxes. I say, you get mine, I get yours. You think that's a quick and dirty way around the Anti-Injunction Act? Then I can sue because I can't seek a refund directly from the OTR of whatever assessments they make against my neighbor. I have a contract with him. And because I can't seek the refund directly, I get to take OTR to court and seek an injunction against any taxes they want to levy.
Well, I think it's a very different scenario than we have here, and we're not saying that you avoid paying taxes. We're just asking for a chance to have our complaint heard in a court. So it's not as if you're evading taxes entirely by sort of working that scenario.
You're seeking a declaratory judgment to abate taxes by 2.1 million for every year going forward. So you are seeking to evade paying taxes and to that tune. Right? To have the landlord, you're seeking a declaratory relief that would result in the landlord not paying those $2.1 million in taxes into, I forget, for another 10 years or so.
The landlord would be responsible for whatever the landlord is responsible for, regardless of the outcome of the litigation. The only difference would be what EAB is entitled under the terms of the incentive agreement that it entered into with the district.
I don't get that answer. The thing that you're saying you're entitled to is an abatement of the property taxes due by your landlord. So why isn't the suit seeking to prevent them from paying that amount of property tax every year?
So well, I say that because it is a performance-based incentive. Yes, it comes in the form of a tax abatement, but it is per the terms of the contract, it exists outside of the tax code. It is a separate agreement under the incentive agreement between the district and a renter. And I do want to point out one of the scenarios that's different from the scenario you had is EAB was required under the incentive agreement to provide its lease to the district for the district to review and confirm that it is in accordance with the incentive agreement and the act, and it did that. So now for the district to now say, it's a little disingenuous for them to now say the lease is insufficient. The lease should have required the landlord to assert claims on behalf of owner when the district reviewed the lease and confirmed it was in accordance with the incentive agreement and the act. And there's no reason to believe EAB even could have convinced the landlord. I mean, the landlord is a third party. So to say that EAB should force a third party to agree to contract terms or to assert claims on its behalf is just not reasonable. And that's squarely in line with the cases cited in our brief, saying that the Anti-Injunction Act should not require any party to rely on the mere possibility of a third party asserting claims on their
Well,
behalf.
let me question you on your premise there as well. We haven't interpreted DC Code 47, 81102 before. And it talks about someone who's owed or who has made a payment. And it does use the word owner as well. You know, do you then have a remedy if we just determine in this case that you have hypothetically determine in this case that you have an interest in something based on the statute that came from your agreement, and therefore you should be able to pursue that administratively through the system that we have set up for resolving tax disputes?
I don't think so, Your Honor, because I think that the jurisdiction is conferred by the DC Council through the statute, and I don't think the court can sort of adjust it, certainly can interpret it. But the statute is quite clear when it defines owner. There's certain subsets. It's not just the record property owner. It can be, and then it lists a number of things. So a tax sale purchaser, there's certain low income, a trust beneficiary. It does include somebody who's a renter with at least 30 years. They could then be an owner for those purposes to appeal an assessment, but EAB does not fit any of the categories that would give jurisdiction to OAB, and I don't think that's disputed by either party. It's the government's really only argument is that the landlord should just do it, and that EAB somehow should make the landlord assert its claims on its behalf. That's just not a viable option. Moving to the second argument. So, and I should say, if the court finds that EAB has no other alternative remedy, that alone is sufficient to reverse and remand. Separately, the act does not apply where there is not, and where the complaint does not seek to enjoin the assessment or collection of any tax. So first, I do want to point out that there's a breach.
Can I just go back to your first argument for a
Sure.
second? So what case do you want me to read for the proposition that if somebody else who you're in some privity with, given the lease here, has the right to seek a refund claim, that does not I take it the Federal Anti-Tax Injunction Act or the cases that you're relying on would not preclude somebody from proceeding in court?
So I would say primarily South Carolina.
And what were the facts in that case?
That was the state of South Carolina sought to challenge
It was something on behalf of their taxpayers.
there were bondholders and they wanted to challenge something related to
And could the bondholders, this was a perspective, I read this, but it's been a while. Just remind me if you can articulate the facts.
the argument was made by the other side that it should be sufficient that the bondholders could assert a claim, and then that would be sufficient because the same remedy that South Carolina would obtain the same remedy if they did. And that's when the court said, no, the Anti-Injunction Act was never meant to require a party to rely on somebody else to file a claim on their behalf. I would actually say too, even it's actually a case cited by the other side that was saying, well, if you have complete control, it's the Franchise Tax Board of California. It's also a Supreme Court case cited by the district. There, the court said, if a party has complete control over the other party, then it can require that party to go.
Like if it were a subsidiary or something like that.
Exactly. So again, I think that just highlights the distinction here is obviously the landlord and the renter are not affiliated in any way.
I mean, is part of your argument, or maybe this fits into 2 or 3, that you don't care one whiff about whether or not the taxes are abated or not. You just want the monetary benefit that you bargained for under the contract. Whether or not that goes back to the landlord, you couldn't care. You know, you sought monetary damages in the trial court, right?
Yes, but it is monetary damages in the form of an abatement, because that's the terms of the incentive agreement. It's paid in the form of an abatement.
Yeah, but that's not monetary damages. You know, you're not seeking monetary damages in the form of an abatement. You're just seeking the money. You know, the trial court isn't affording you relief. I mean, I'm separating out sort of the retrospective relief for the damages that you've claimed and the monetary damages you're claiming, and the forward-looking declaratory relief that you're seeking, which I think there's, you know, there might be slightly different issues in terms of the Injunction Act's application to those different forms of relief. But as to the monetary damages, you're not saying, I don't think, correct me if I'm wrong, give our landlord a refund. I think what you're saying is give us our money.
I think you're right, Your Honor, because it is, we are talking about past years, the taxes have been paid. I personally don't know that there is a way to funnel it through. I think it would have to, I guess, be in the form of monetary damages for past years. And that actually brings me to the point I was about to make, which is a suit seeking to enjoin the collection or assessment of taxes first certainly does not apply to any past years. So, you know, when we brought the complaint, it was in 2022 for tax year 2021. It's a 10-year incentive program. We're obviously halfway through that or about to be. And any past years taxes have been collected, paid, it would not be enjoining past years. And at a minimum, the court should not have dismissed the breach of contract claim for any past years. And even looking to future years, I mean, courts have held that just because a suit might ultimately affect the collection of taxes or the assessment does not mean that the Anti-Injunction Act automatically applies. So there are always scenarios where if you look at the relief sought, it's something different that just might affect the collection and assessment of taxes. And we have that here because EAB is not an owner. EAB rents. EAB's complaint really cannot affect the collection of a third party's taxes. The third party is going to pay or not pay, you know, independently of EAB, and the complaint really exists separately.
If I could pause you for a moment, help me understand it. If the taxes owed did not exceed the $2.1 million threshold entirely, would it still be, in your view, that the government still has to provide 2.1 million, and then per your agreement, the tax, all of that, including the excess, just flows through to you?
No, Your Honor, because and we're saying if the entire building's taxes were under 2.1, because the language of the incentive agreement says that the incentive shall come in the form of 2.1 million in the form of an abatement, it can only receive the money in the form of an abatement. EAB would not, you know, ask for a check on top of the abatement. But we do believe that whatever, as much money in the entire building, up to 2.1 million in the form of an abatement would flow to EAB that is available. And actually there's a term in the lease, at least between the landlord and EAB, that recognizes that. There's a term that says, you know, EAB should not be responsible for paying above the entire building. So tax liability for that year. So if the entire building were assessed at 1.5 million, the landlord would only need to pay 1.5 million to EAB.
Yeah, that's just a very weird, I mean, it's not before us. We don't have the merits, any kind of merits ruling before us, but it's a very weird reading of the contract. Why on earth would the accident, I mean, it strikes me as a happy accident for you that you happen to only have 48% of this building occupied. So only for that reason could you get a $2.1 million abatement. Whereas if you exhausted the building and it were only 48% of its size, you would not get that money back. It's going to be an uphill battle, I think, counsel, no matter where you end up litigating this.
Well, luckily we're not determining the merits here today. It's more of just a question of whether the Anti-Injunction Act applies. But But certainly, I mean, the risk was borne by both parties, and it is part of EAB's requirements were to hire 35 new district employees every year to grow by 350 new employees over 10 years. So there is a expectation that they would expand and maybe grow inside the building, maybe eventually occupy 100% of the building, and maybe they would lose money on the deal. But we read the contract as a set 2.1 million. Regardless.
Only if the entirety of the building's tax obligation exceeds that amount.
Right, and there's really two exceptions. There's that exception, and if they don't meet all of the qualifications, they can then receive less than the 2.1 million, which is why it says, you know, up to 2.1 million, depending on if they didn't hire, if they hired 20 instead of 35 district residents, et cetera. I see my time has ended. May I briefly conclude?
Yes.
Okay. EAB respectfully requests that the court reverse the Superior Court's dismissal of EAB's complaint for each of the three reasons indicated in our brief and remand for further proceedings.
Thank you, Ms. Gearhart. We will give you the 3 minutes you requested, even though we used up your time. We'll hear from the district.
Thank you. Good morning, and may it please the court. Jeremy Girton for the District of Columbia. The Anti-Injunction Act has two related aims. The first is to prevent interference with tax collection efforts, and the second is to prevent circumvention of statutory refund remedies. EAB's suit here fails both principles because it seeks a declaratory judgment about how the district should assess and collect taxes going forward, and it does so outside of the statutory refund process. EAB cannot evade the act by recharacterizing its suit as a contract action because the only contractual obligation of the district at issue in this case is the district's statutory duty to assess and collect property taxes correctly. I welcome the court's questions on any of the issues discussed already this morning.
Well, so I mean, the first point you raise doesn't address the retrospective relief that they sought, right? The forward-looking, you know, declaratory relief request is one thing. But they also say, and we want some monetary damages to the tune of something like $840,000 for the last year. That has, I mean, that could, through collateral estoppel principles, end up having some forward-looking consequences for the district, but it doesn't seek an injunction of collecting. It doesn't do anything to stop the district from collecting taxes, right?
That's right. It does affect the second aim of the Anti-Injunction Act, which is to evade the statutory requirements, the administrative exhaustion.
Right. So you're kind of stuck with that second leg of your stool. And this problem with the second leg of your stool is that they don't have any right to seek a refund through the administrative refund process, right?
So they don't for 2021 only because of the way they structured their lease with the landlord and the way that they decided to pay these taxes through a third party. But I don't think that that means that the refund remedy is unavailable in the sense that the Anti-Injunction Act talks about. Just the same way as if a party blows past a statute of limitations, it doesn't mean that the action wasn't available. It just means that they have taken some action that makes it no longer available to them.
Well, help me with that there a little bit. Like, is it normal for a business leasing a property to say, oh, and we'll pay the property taxes for it?
Yes, that's a standard term of triple net leases for commercial tenants. This sort of arrangement happens all the time in the district. And if there's some dispute over, for example, probably more commonly, how much the property is valued at, right? So that's a big part of how you decide how much taxes to collect. If there's some dispute about that and the tenant says, under my lease, I'm obligated to pay the taxes, but I think that the district has really overvalued this property and the amount of taxes should be less. They have to work with the landlord or the owner of the building to bring a refund claim. Because the owner of the building is the one who pays the taxes on the property in rem. And so that's a pretty standard procedure. It happens all the time. You can bring the case to OTR. They can bring it together. They can kind of have the owner as the nominal party, and they can, you know, provide all of the litigation resources. There's lots of ways to do that. And normally tenants and landlords work that out as part of their lease agreement. In this case, they chose to write a lease agreement that absolved the landlord of any responsibility to do anything with relation to this abatement. I think that might have been an unfortunate contracting choice on their part, But it doesn't mean that the remedy is unavailable kind of in the world. It just means that they have taken affirmative steps that maybe make it unavailable to them. There's another option available as well, which is that they could have worked out with the landlord to be the payer of all the taxes on the building directly, and then they would become the person under the statute who would have the right to bring a refund claim. So there's two options here, and they've chosen to not take either of them. But I don't think that means that they get to evade the normal refund process that applies to everybody else.
What about the language in South Carolina?
So I think South Carolina is a very different case than this one. It involved effects on the state, not because taxes were flowing from the state through a third party to the federal government, but through the operation of the market. The issue was changing the tax treatment of bearer bonds issued by the state. And the resulting harm to South Carolina was going to be that the interest rates that they could charge were going to be lower because there would be less demand for the type of bonds that they wanted to issue. So that's a very indirect chain of events to get back to South Carolina's injuries. And South Carolina wasn't in privity with another party that could have brought the suit. And I think that that is mentioned explicitly in footnote 17 of the decision, where the court says this ruling is not going to allow people to evade the normal refund process by just artificially doing something like Judge Deal's question, swapping tax responsibilities with a neighbor, or forming an organization of taxpayers where the organization couldn't bring the refund claim because it's not the taxpayer, but the taxpayers themselves could have brought that remedy. So it was pretty clear that you're not able to evade the Anti-Injunction Act just through some sort of legal formalism. And I think here, the two parties, the owner and the tenant, have every incentive to work together to lower their tax bill if they think that it should be lower.
Are you saying they were required to work together?
No, they're not. But if they want to bring a refund claim, then the person who pays the taxes has to bring the refund claim. And if that person doesn't want to bring a refund claim, then they don't have to. But that's them choosing not to avail themselves of a remedy.
The landlord has no interest in a refund claim. It doesn't get anything.
Well, only because of the way their lease has been structured.
Yeah, I mean, maybe, I don't, maybe they could restructure their lease, but in terms of the money that they say that they're owed for, the past tax years, landlord has no interest in that. Why? And also, why put that through an administrative proceeding about tax assessment when this is a very classic contract dispute? I mean, the question here is, how do you read this contract? I think it seems to me that the district probably has the better reading of the contract. Doesn't make a whole lot of sense to abate taxes to the tune of 2.1 million for a tenant who doesn't, whose share of a property doesn't amount to that much. Okay. What expertise does an administrative refund proceeding have that a court doesn't in addressing that question?
So two responses there, Judge Deal. The first part, I think that the reason that the landlord doesn't have an incentive here is only because of the terms of the contract, the lease between the two parties. They could have structured the lease differently and said that the landlord keeps all the abatement as part of our rent obligation. They could have done lots of different things. The district didn't have any part in writing that lease agreement. We passed the statute before the lease was even signed. So I don't think that it's necessarily true that the landlord would never have had an incentive. They could very well have had every incentive to bring this. So that's the first answer to your question.
I mean, yeah, I just meant to say they don't. Not that is an inevitable circumstance about the world. But at the moment, there's no reason for them. They don't have an interest in how this is resolved. They owe some money to OTR or they owe some money to EAB. What do they care?
Right. And again, that's because of the way EAB decided to write its lease. I don't think we're responsible for that in the sense.
Why would this seeming contract dispute be better resolved in an administrative refund proceeding rather than in court?
So I think characterizing it as a contract dispute is wrong. The term that we are fighting about here, as was just acknowledged by my friend Ms. Gearhart, is the statutory definition of what property gets abated. We think, according to the statute, it's the portion of the property that they lease. They think it's the whole address. That is a statutory term.
Question in the briefing, they make the point on the statute, not that it's about our property versus this property. They just say it straight up says, as it does at C1, it will equal this, and that seems to be an ambiguity in there.
So if you look at page 12 of their reply brief, I think that's the clearest place where they acknowledge this. They say that really what we're fighting about is should the abatement apply to a portion of the property, as the statute says and defines the term property, or does it apply to the whole thing? And I think as Ms. Gearhart acknowledged today, they agree that if the whole property's entire tax obligation prior to abatement was less than 2.1, they would not get 2.1 million, they would get something less. So they're acknowledging that the total value of the property itself is a cap and that it's not refundable. So then really all we're fighting about is what is the baseline property that we're talking about in terms of what gets abated. And I think they also acknowledge at page 12 of their reply that the way that this works is that you abate the property's taxes prior to collection. So she said several times that their action won't affect collection going forward. And that's just wrong because it's not the case that the district collects $2.8 million from the owner and then pays back 2.1 million or whatever, 1.5 million. It just doesn't collect that money in the first place. The property in REM is what is taxed and that is what is abated. So if their suit were to succeed, we would be collecting less each year than we are now. And so it does definitely affect collection.
So it begs the question in terms of what Judge Deal asked already. Why is the administrative process better for that when it's based on this term and not a traditional function of what we're looking at, like actual assessment?
Right. And thank you for redirecting me back to Judge Deal's question. I think there's two reasons. One is that was a policy choice that Congress and the council made when they wrote the tax refund statutes, that they were going to funnel these things through administrative processes and that those were mandatory. And so if you look at the Craig decision, it said not only these mandatory steps you need to take, they're jurisdictional steps. So without taking those administrative refund options, you lose jurisdiction in the Superior Court entirely because there's no general equitable jurisdiction for tax refund claims. So that's the first reason. It's kind of just a policy choice that we've decided you have to go through this route. And then the second is that this is a tax statute over which OTR has some expertise in applying. I think that their very thoughtful letter in response to EAB's request shows that they analyzed the statute. They talked about how this is a common arrangement to have a triple net lease function this way. And when you do, you have to work with the landlord as the owner. And that's just kind of how taxes work and how abatements work and how assessments work. So all of that expertise, I think, is really valuable here. And I think we can see it from the two sides' briefs, which disagree about kind of a lot of basic tax terminology about what is an assessment, what is an abatement, what does non-refundable mean. Those are all kind of terms of art in the tax context where OTR's expertise, I think, would come in. And I did want to talk a little bit more about the Craig decision because I think it's really helpful for understanding how even suits that might have some retrospective relief that they're seeking for past taxes that have already been paid are still barred by the Anti-Injunction Act in this context. So Craig was a group of property tax owners who had paid their taxes but thought that they were assessed incorrectly. Some of them had gone through the administrative process and some of them had not. And the court dismissed all of the parties who had not availed themselves of the administrative refund and said that this is a jurisdictional requirement. It is required by the Anti-Injunction Act and it's required by the kind of focus of the act on anti-evasion. And so those cases were just dismissed, even though, you know, they didn't have any other remedy at that point because they hadn't gone through the administrative process. So I think the Anti-Injunction Act applies both forward and backward to prevent interruptions with tax collection and to prevent evasion of statutory remedies.
I mean, the way, I guess I'm just looking at the language of Craig, and maybe this is just inconsistent with the facts on the ground, but it seems to be talking only about the when it's talking about violation of the Anti-Injunction Act, it seems to be talking about the sought declaratory and injunctive relief. I think you're telling me that it was also seeking, you know, a refund and that we also said the Anti-Injunction Act would bar that suit?
Yes, so
what language in the Anti-Injunction Act would bar a suit for monetary damage? I mean, I understand the argument that, you know, there's a different administrative avenue that you need to pursue? What's the Anti-Injunction Act have to say about seeking damages after the fact?
So I think the best language from Craig is at the top of 958, and just before on 957. The court said, in sum, as to most members of the class of the tax division certified in these cases, the jurisdictional prerequisites for allowing the taxpayers to bring refund suits to challenge their assessments were neither satisfied nor excused. Accordingly, the class action was barred under the Anti-Injunction Act. So I think that's the court acknowledging that even when you have a taxpayer who paid the taxes already and is seeking some form of declaratory relief about that past payment, the Anti-Injunction Act still applies if you don't go through the refund statutory procedures and administrative exhaustion first. And so we read that case as barring both aspects of EAB's case here, both the forward-looking and the backward-looking relief. I wanted to address, Judge Howard, your question about whether under 811.02 EAB could be considered a taxpayer to bring the suit directly. They could if they were the one who made the tax payment. So the statute says, I think she quoted from 825, but I think you were talking about 811, says the person who made the payment is the person who can seek a refund. So if they had chosen to make the payment, they could have been the person who brings the refund claim, because in rem taxation doesn't really matter who pays and what their relationship to the property is. It's just someone has to pay on behalf of the property. So they definitely could under that, but because they chose not to do that here, they wouldn't have that remedy, at least for the 2021 year.
Let me direct you on from there. We, there's been some discussion so far in the argument that we're not really addressing the merits today, but it seemed to be an explicit point in your briefing that we have to at least glance that way, because the Anti-Injunction Act, at least DC's, it's not just there is no other remedy available, but there's no possibility of DC having any success on the merits. Could you talk about that some for us?
Yes, so the standard is very high. You have to show that the government has no chance of success, meaning that EAB is certain to succeed. And I think in this case, we really have the opposite, where EAB's chances of success are very low. Essentially, what they are asking the court on the merits to do is say, even though the word property is defined in the statute as a portion of this address, and then that is what is going to get abated. And even though we only rent a portion of this building, the entire property is what should get abated. And then I think they're going a step further than that, at least in the complaint, although I understand they've sort of walked back from that, and saying the result is that you should pay damages directly to EAB. And I think that's really a strange way for them to have structured what they were asking for. I think, to use an example similar to Judge Deal, your hypothetical, if I lent a family member some money and they said, I will pay you back with my federal income tax refund once I get it, because it's going to be more than enough to cover what I owe you. And then they say, oh, there was some problem. The IRS didn't give me as much refund as I thought, so I can't pay you back. They're saying that I would have the right to sue for damages against the IRS because of how they calculated the tax refund, just because I was owed money by the taxpayer. And I think that that is totally not what the Anti-Injunction Act permits.
It doesn't seem so analogous here, though, because it's in this point, it's the end user, it's you who has the agreement with the IRS to return the money to the intermediary. And what you're complaining about is them breaching that agreement with you, not about you're not trying to assert the rights of the intermediary.
Well, I think they are trying to assert the rights of the intermediary here. And I think the reason that analogy is pretty close is because of in rem taxation, because this property is what is getting taxed. And so it doesn't really matter who paid it or who's bringing the claim. It's that the property is what was taxed and what gets abated. And so I think that that's essentially what they're saying is somebody else paid taxes on this property. I think they paid too much in taxes on that property. And because I was intended to be the beneficiary of this abatement, I get to sue directly for damages instead of flowing through the way the abatement normally works. And I think that that's just totally wrong, and it would expose the district to double recovery because the landlord would still also be able to pursue a tax refund claim through the normal process and potentially get the money back. If they're right about how the statute should be read, then we're obligated to pay the landlord and we're obligated to pay EAB as a result of this suit. And so then we have a double recovery problem. And so I think that they have come around to acknowledging that the way that this works is we just reduce the amount of taxes at the beginning. And so even if they were to succeed, it would have to be through some sort of remedy where we reduce the amount of money charged on the property itself at the outset. And then through their lease agreement, the landlord would pay them some money that they got as a result. It wouldn't be direct damages to EAB. So even though that's what they kind of said in their complaint, I think they've come around to acknowledging that that's not how it would actually work in the real world. I think unless the court has any further questions, we would just ask the court to affirm. Thank you.
Thanks, Mr. Gerton. Ms. Gearhart will give you 3 minutes.
Thank you. So first, I just want to emphasize that the district's council agrees that EAB has no available remedy to it. They say it's EAB's fault, but they agree that currently, if the court affirms the decision below, EAB will leave here and have no remedy. And I did want to also briefly touch on a point by Judge Howard mentioning that the merits are necessary to consider. I just want to clarify that is only if we get to step 3, which is the exception. So there's this, they refer to it as the Williams packing exception. It has the 2 prongs and then you would look at the merits. But the South Carolina specifically said Williams packing is not the only exception, and it carved out, there's an additional exception, which is if there is no other remedy. So that stands on its own. If there is no other remedy, then that alone supports reversal. To the point about it's EAB's fault that it doesn't have a remedy. I want to we'll emphasize one that's just nowhere in the case law that sort of if it's not your own remedy of your own doing, that's not in the case law. Also, I don't think it is fair or accurate to say that it is EAB's fault. Again, EAB cannot force a third party to agree to terms that are not may not be helpful to it. And then I did just want to point out, I want to actually just read the portion of the incentive agreement. This is JA 103, says that this is part of the terms of the incentive agreement. The company shall provide the district a copy of the relevant portions of the lease once executed for the district to confirm the lease meets the requirements of this incentive agreement and the act. So that was done. The district received the lease, reviewed it, and when ultimately DEMPED certified that EAB had satisfied all the conditions of the incentive agreement. I mean, essentially the district reviewed the lease and said, this is fine. And even though the landlord was not required to assert claims on behalf of EAB.
I don't understand what that goes to. So let me see if I can try to put a point on it. I think what you're saying is, one point that the district makes is, in a triple net lease, it's fairly standard that, I think they're saying something like, you guys have done something abnormal, and that's the only reason you don't have a right or your landlord isn't incentivized to bring their own refund suit. You guys have sort of bucked the trend, and you shouldn't let litigants through these creative pathways buck those trends. Generally this stuff should be going through a standard administrative refund suit. So are you raising the district's approval of the lease to say, look, the time to complain about that was then?
Yes, I'd say essentially they waived their argument or that, right, that the district.
We kind of gave them notice that we wouldn't have an administrative refund suit available to us. They should have said, hey guys, we don't like this structure because it could drag us into court in a way that we don't want it to. So structure it the normal way. Or we're not going to approve it. That's kind of the argument.
Yes,
Okay.
yes, Your Honor. And to the point about the triple net lease being, this is an ordinary course, and all the time landlords just work with their tenants to bring cases together. I think if it were such a regular occurrence, owner, there's like 5 subparts under the definition of who can bring claims. The district council could have chosen to say that the tenant in a triple net lease can bring their own claims, and they chose not to. So we have to read the terms of the statute as they are. And despite being a regular occurrence, tenants under a triple net lease are not permitted appeal rights. And then I did lastly just want to touch on, even if the landlord had agreed under the terms of the lease that it would assert claims on EAB's behalf, the remedy still is not adequate. So to Judge Deal's point from earlier, this is a breach of contract case. It is seeking damages for past money owed. It does require interpretation of contract terms. I think the statute's clear on the limitations of what the Tax Appeals Commission can do and OTR can do, and it talks a lot about reassessing the value of a property, reassessing the classification if you're a vacant property or not. It is reassessing elements that would not adequately remedy EAB's complaints in this case. So it's just not an adequate remedy, regardless, even if landlord did agree to pursue the claim, it's not the place to resolve the breach of contract.
I'm not sure I get that claim. I'm not sure I get that argument either. But I mean, there's nothing in the contract that entitles you to say, treble damages or something like that, where you could say, look, a refund suit isn't going to do that. But maybe your argument is like, look, if we said damages plus $2, then we'd be in court right now because a refund suit couldn't accomplish that contractual remedy. But I don't think there's anything in the contract itself that gives you anything but the abatement itself, right?
Correct, except for past years, we'd be seeking remedy for past years and the damages for past years, and the time limit is limited. You can only bring a tax refund suit for the prior tax year at issue, 1 year at a time. So it's sort of limited in time, backwards looking, and then it's this sort of injunctive relief of revaluing property and things that that would not provide relief to EAB. So unless your honors have any questions, EAB requests that the court reverse the decision below. Thank you.
Thank you very much. We will take the case under advisement. Thank you both.
All right.